The easiest way to take a field is not with a bulldozer. It is with a document that looks complete, a deadline that feels immediate, and the quiet assumption that nobody living will dig far enough back to prove otherwise. Most land is not lost in court or in combat. It is lost in that smaller, colder moment when an ordinary person is made to feel that the system has already decided. On the morning of October 17, 1992, 15-year-old Eli Mercer came over the rise at the edge of Willow Creek Road and saw, in the pale half-light before sunrise, 3 white trucks parked nose to tail beside Ada Kincaid's north pasture. Their headlights cut through the fog in long clean blades. A drilling rig sat angled toward the field. Men in orange helmets were unloading lattice sections from a flatbed trailer. A surveyor in a green rain jacket was walking the grass with a prism pole, stopping every few yards to tap a fluorescent stake into ground that had been in the Kincaid family longer than the county had been paved. Eli knew that pasture the way boys know the places that framed their childhood. In spring it flooded shallow and silver. In July it smelled like clover and cut hay. In winter the low shelf near the spring stayed dark and soft under the frost because water moved beneath it even when everything else looked dead. He also knew something else with the certainty of habit. Ada Kincaid did not lease land to anyone. She did not sell corners, allow shortcuts, or tolerate men explaining her own property to her from the seat of a truck. And yet there they were, already moving as if permission were the least important part of the morning. Eli left his bicycle against the fence and watched long enough to understand that this was not a mistake. The men had maps. They had painted marks in the grass. 2 boreholes had already been started near the spring shelf on the eastern side of the pasture, exactly where no one in the valley drove heavy equipment unless the season was bone dry. The foreman, a thick-necked man named Randall Price, carried a clipboard under one arm and a rolled set of plans in the other. He looked like someone who had spent a decade arriving on other people's land with practiced certainty and leaving before the real consequences of his arrival had ripened. He worked for Valley Grid Transmission Cooperative, a regional utility expanding a high-capacity line across 4 rural counties. In the previous 3 years Valley Grid had crossed orchards, hayfields, timber edges, drainage ditches, and 1 church parking lot. They had become very good at one thing, appearing with paper, using the paper to create inevitability, and letting that sense of inevitability do most of the work. Eli rode hard back to the Kincaid place, tires spitting gravel, and found Ada in the machine shed standing over the open housing of an old Massey Ferguson hydraulic pump. She was 71, slight in the shoulders, steel gray hair pulled tight, with the wiry posture of someone who had carried feed sacks in stubborn weather for half a century and had long ago stopped wasting motion. She listened without interrupting while Eli, breathless and furious on her behalf, told her about the trucks, the stakes, the drilling rig, the men already in the pasture. She did not ask whether he was sure. She asked how many trailers. How far from the fence line. Whether the holes were north of the spring run or south of it. When he answered, she wiped her hands on a rag, folded it once, laid it on the workbench, and looked out through the shed opening toward the far field with an expression so still it almost looked blank. But it was not blank. It was calculation. 6 days earlier Randall Price had come to her kitchen with a photocopy of a 1958 utility easement and the polished patience of a man delivering what he considered unpleasant but settled news. The copy stated that her father, Vernon Kincaid, had granted Central Valley Electric, Valley Grid's predecessor, the right to place and maintain transmission structures across a defined portion of the family's acreage. Price had pointed to a shaded route on an updated engineering map and explained that 3 steel towers and an access track would cross the north pasture diagonally from the county road toward the ridge. Ada had not argued then. She had done something that unsettled him more than anger would have. She had read the document slowly, asked for the original recording reference, asked for the full title packet, and then asked a question he did not expect from a woman he had already sorted in his mind into the category of eventual compliance. She asked what the copy omitted. Price gave a brief professional smile and said the copy omitted nothing material. Ada asked again for the full chain of record, including any prior easements incorporated by reference. Price said what men like him always say when the system is leaning in their favor. If there had been anything affecting placement, engineering would have found it. Ada had looked at him over the rim of her glasses and said, "That is not the same thing as saying it doesn't exist." He told her construction would begin the following week. Now it had. By noon the news had reached the neighboring farms, and by evening 4 people were on Ada's porch because that is how rural counties still process the beginning of a fight. Not through announcements, but through vehicles pulling into dirt drives and men taking off caps in the cooling dark. There was Joel Ramsey from across the creek, who had lost an acre and a half to a widening county road in 1978 and still talked about it like a funeral. There was Miriam Shaw, who knew every ownership change along Willow Creek Road back to the war years because she had kept books for the grain co-op. There was Luther Bell, who had once taken a drainage dispute all the way to district court and learned the expensive difference between being morally right and procedurally prepared. They did not come to encourage her. They came to give her the wisdom of experience, and experience in such places often arrives wearing the face of surrender. Joel said once the augers start, the thing is moving. Luther said utility lawyers live on delay and attrition, not truth. Miriam said if the county signed off, somebody somewhere had already decided the route. Ada listened to all of it with the same stillness she had shown Eli. Then she asked Miriam whether the recorder's basement still held pre-war plat ledgers and whether anyone at the clerk's office still knew how the old cross index worked before the county reorganization in 1969. That changed the air on the porch. Because it revealed that Ada was not looking for sympathy. She was looking for an older door into the system. Later, after the others had gone and the porch had fallen quiet except for crickets and the distant pulse of truck engines from the road, Eli, who had not entirely left and was sitting 2 steps down with his elbows on his knees, heard Ada say into the darkness, almost to herself, "My father told me about a restriction that came before the power line. He said the electric easement only stood where the older one allowed it to stand." Eli turned. Ada did not look at him. She kept speaking the way people do when memory is not a performance but a retrieval. Her father had told her in the final week of his life, in a hospital room that smelled of starch, metal rails, and antiseptic, about an agreement recorded in 1908 when the county authorized a telegraph and road improvement corridor through the valley. Ada's grandfather, August Kincaid, had agreed to let poles and maintenance access cross the property, but only along the western lane above the wagon road and never within 150 feet of the spring shelf that fed the lower pasture. August had been obsessive about water. He believed land was not just surface but movement under surface, and that a careless trench in the wrong place could alter drainage for a generation. When Central Valley Electric came in 1958 seeking a wider transmission easement, Vernon Kincaid had agreed only on the condition that every prior corridor limit remained binding. He had told Ada, as clearly as a man can tell anything to a daughter he knows will have to remember it without him, that the power company's rights were real but narrower than the company would one day pretend. This is how hidden systems work. They do not erase the truth. They bury it under convenience, turnover, summaries, assumptions, and the very human fact that most people are too busy surviving to become archivists of their own rights. An easement sounds simple in conversation, but on paper it is a chain. One grant can carry another inside it. One paragraph can quietly subordinate a whole corporation to a promise made 80 years earlier by men with ink on their sleeves and mud on their boots. The company knew the 1958 document existed. What Ada suspected was that they were relying on nobody having the time, memory, or stamina to find the document that constrained it. On Monday morning she drove to the Marston County Clerk's office in a brown pickup that had more rust than paint on the bed rails and asked for the complete recorded history on Parcel 14B, Kincaid Farm, from 1900 forward. The clerk at the counter, young, pleasant, and immediately overwhelmed by the request, found deeds and transfers back to 1941, then paused at the edge of the digital system like someone standing at the lip of a dark well. Anything earlier, she said, would be in the lower archive, and the lower archive was only partly indexed because water damage from a broken line in 1962 had interrupted a records conversion nobody ever finished. Ada thanked her and asked who remembered the old corridor books. The clerk thought for a moment and said there was one man who might. His name was Bernard Vale, a retired assessor who worked part-time 2 mornings a week helping with historical record requests because he was one of the last people alive who understood how the county used to file right-of-way notices before standard parcel numbering. Bernard Vale turned out to be 78, narrow-faced, with suspenders, careful hands, and a memory so exact it felt almost unnatural. He looked at Ada's parcel description, looked at the margin note on the 1958 copy she had brought, and said if there was a prior corridor restriction, it might not be under Kincaid at all. It might be indexed under road improvements, telegraph authorities, drainage commissioners, or even under the old beat district name the county stopped using in 1921. That was the first real crack in the illusion of Valley Grid's certainty. Because once a person understands where the official record can hide, inevitability loses some of its power. Ada and Bernard spent 2 days in the basement archive under humming fluorescent lights that flattened time. The room smelled of paper dust, damp cardboard, and cold concrete. Some ledgers were shelved. Others were stacked in leaning towers on metal carts. Parcel maps from one decade had been folded inside tax rolls from another. Old road petitions sat tied with cotton tape. Some books were indexed by grantor. Some by grantee. Some by township. Some by categories no modern clerk would invent on purpose. Eli came after school and on Saturday morning, carrying boxes, refolding survey sheets, writing references on legal pads when Bernard called them out. It was the kind of labor no company expects from the people it plans to outlast. By the afternoon of the second day they had found nothing decisive, and that is the point at which most fights quietly die. Not because the right answer does not exist, but because exhaustion begins to look like reality. Ada felt it. Bernard felt it too, though he hid it behind dry procedural remarks. Then, late on the third morning, Bernard asked for a set of uncatalogued corridor books stored behind the old plat cabinets, volumes that had been pulled after the pipe break in 1962 and never re-entered correctly into the archive map. In the third of those books, between a petition for bridge timbers and a 1911 drainage levy, there was a folded attachment packet on onion skin paper bearing the seal of the Marston County Road and Telegraph Board. It was dated June 3, 1908. It named August Kincaid. It described, with measured distances and survey bearings, a utility access corridor along the western lane of the property. And in language so plain it almost felt modern, it said that no current or future line, pole, tower, trench, support structure, or maintenance road serving a public communication or electrical function could be placed east of the described corridor or within 150 feet of the spring shelf and seep line feeding the lower pasture. It went further. It stated that any subsequent grant affecting the parcel would be subject to the foregoing limitations unless expressly extinguished by recorded release executed by both the landowner and the operating authority. There was no release in the file. No superseding grant. No extinguishment. Just a recorded promise, older than everyone now arguing over the field, sitting in a basement book while a corporation drilled holes in the wrong side of a pasture because history is only powerless when nobody retrieves it. Ada read the packet once, then again, then a third time with Bernard leaning over her shoulder. She did not gasp. She did not smile. She simply exhaled through her nose and touched the seal with one finger as if confirming that paper could still carry weight after nearly a century. Bernard, who had seen enough property fights to know when a case shifts from grievance to leverage, said quietly, "If your 1958 easement references prior restrictions of record, they've got a problem." That afternoon Ada drove straight to Lena Crow, a land use attorney in Dawson who had spent 22 years handling boundary disputes, timber trespass claims, agricultural leases, and the slow terrible misunderstandings that happen when local knowledge meets institutional paperwork. Lena received Ada as she received all walk-ins, with measured courtesy and an eye on the clock. That changed within minutes. She read the 1908 packet. She read the 1958 easement. Then she turned back to the 1958 document and ran a pen under one sentence in paragraph 4. Subject to all prior restrictions, rights-of-way, and operating conditions of record affecting the described parcel. Standard language, except standard language only looks harmless when no one bothers to enforce it. Lena explained the mechanism as clearly as a surgeon naming arteries. Valley Grid's rights were derivative. They inherited what Central Valley Electric received in 1958, and Central Valley Electric had received its grants subject to whatever older restrictions remained active in the record. The 1908 corridor limitation had never been released. That meant the company did not possess the broad diagonal crossing shown on its engineering map. It possessed a narrower route along the west lane, precisely where August Kincaid had insisted such structures belong. Lena also explained why this sort of abuse happens so often. Companies do title work to the point of confidence, not necessarily to the point of truth. Survey teams rely on packets assembled by legal departments. Legal departments rely on title summaries. Title summaries are built by people who are overworked, rushed, or incentivized to solve forward, not backward. And once a route is approved, every layer below it begins acting as if approval itself proves correctness. It does not. It only proves that paperwork has hardened into momentum. Ada asked the only question that mattered. Can they be stopped before the steel goes up? Lena said yes, if the court moved quickly, and no, if Valley Grid managed to create facts on the ground before an injunction landed. This is another hidden system most people never learn until it is aimed at them. Institutions love completed work because completed work changes the emotional math. Once a tower stands, judges think differently. Neighbors think differently. Even the owner begins to think differently. A wrong that exists on paper can still be undone. A wrong that has become concrete, rebar, and sunk cost starts to feel permanent even when it isn't. Lena filed for an emergency injunction that Friday. Attached to it were the 1908 corridor grant, the 1958 easement, photographs of the boreholes near the spring shelf, and a sworn statement from Ada explaining the hydrology of the pasture in the blunt practical language of someone who had watched that land move water for 60 years. By Monday, Valley Grid's project office had moved from certainty to irritation. By Tuesday, irritation had turned into alarm. Randall Price made calls upward with the tone of a man who believes a minor local complication will be corrected by bigger people in cleaner offices. But the county planning director, once shown the full chain of record, suspended his placement approval pending legal review. Valley Grid hired outside counsel from Lexington. Their first instinct was denial. They suggested the 1908 record might be obsolete, maybe administrative, maybe too remote to control modern electrical infrastructure. Their own title researcher then went to Marston County, found the same packet Bernard had found, and eliminated the easy argument that the document was fabricated or unreliable. So they shifted, as large systems do, from saying the truth is false to saying the truth is irrelevant. They argued abandonment. They argued dormancy. They argued changed conditions. Lena Crow answered with a brief that cut through all of it. Recorded restrictions do not vanish because a company forgot them. Non-enforcement is not extinction. A later easement that expressly accepts prior restrictions does not erase those restrictions, it reaffirms them. The hearing was held 19 days after Eli first saw the trucks in the fog. Ada sat in the front row in a dark wool coat with her hands folded over a manila folder. Randall Price sat 3 seats behind company counsel, looking like a man discovering that confidence is not a legal theory. The judge did not deliver a grand speech. Real power rarely performs when paperwork is enough. He reviewed the chain, asked whether Valley Grid could demonstrate an extinguishment of the 1908 corridor limitation, received no such proof, and granted the injunction. All work on the eastern alignment stopped that afternoon. The drilling rig left before sundown. The partially bored holes remained for weeks, ringed with orange fencing, shallow scars and wet grass. Eli rode past them almost every day. At first they looked ugly. Then they began to mean something else. They became a shape the whole county could understand, the exact dimensions of what nearly happens when a simplified copy outruns the original record. Winter turned the dispute from urgent to technical. Valley Grid knew by then that it could not simply overpower the document. So it pivoted to the only terrain left: cost, delay, and interpretation. Their lawyers requested a joint survey. Their engineers argued that even if the West Lane corridor controlled, its width might be insufficient for the transmission line. Ada knew better. So did the land. On a gray December morning, survey crews from both sides walked the property with total stations, chains, marker pins, and old bearings lifted from the 1908 packet. Ada walked with them. She showed them the stone corner her grandfather had set. She showed them the surviving post by the lane. She showed them where springwater surfaced in March and why no sane farmer ever cut deep into that shelf. She did not need a hydrologist to explain her own field. What she had, which no consultant could manufacture in an afternoon, was continuity. She knew what the ground did after drought, after hard frost, after 2 days of cold rain, after a January thaw, after a wet April, after 10,000 ordinary observations made by people who had stayed. The survey confirmed what the 1908 record had said all along. The West Corridor was viable. Narrower than Valley Grid preferred, yes. More inconvenient for access, yes. But workable. All 3 planned eastern placements were outside the lawful corridor. The line could be built. It just could not be built where the company had decided it was easiest. And that is the deeper system hidden under almost every story like this. Convenience masquerades as authority. Efficiency dresses itself up as entitlement. A corporation calls the shortest route the practical route, then slowly begins to treat practical as synonymous with permitted. But property law, when actually followed instead of merely invoked, is not built to protect convenience. It is built to preserve consent across time. In January, the negotiation became ugly in a quieter, more bureaucratic way. Valley Grid wanted Ada to absorb some survey costs because, they claimed, the 1908 record had been difficult to locate. Lena answered that difficulty of retrieval does not shift legal responsibility. Valley Grid argued the eastern boreholes were preliminary and caused minimal damage. Ada produced photographs of the churned access lane and statements about crop disturbance around the spring shelf. Valley Grid wanted future maintenance rights broad enough to keep its crews from revisiting title history every time a truck rolled onto the property. Lena insisted on pre-approval language, written notice, and acknowledgement of the corridor boundary in every future operation file attached to the parcel. The company resisted hardest where it mattered most, because systems do not mind paying money nearly as much as they mind creating precedents that reduce future shortcuts. The settlement was signed on March 11, 1993. Valley Grid agreed to relocate the transmission structures to the Western Lane corridor defined by the 1908 restriction and incorporated into the 1958 easement. It agreed to restore the eastern bore sites and damaged access ground at its own expense. It agreed to compensate Ada for disturbance and delay. It agreed that any maintenance, upgrade, or expansion affecting the Kincaid parcel would require written notice and a documented review of the full recorded title chain. Randall Price was not present. He had been transferred in December to a different district, which is the sort of administrative movement institutions call routine when they hope memory will thin out before blame settles. The replacement project manager, a younger man named Colin Reeves, came in April to walk the revised route. He carried a thick file. He had tabs on the old record packet. He did not speak to Ada as if explanation were a form of dominance. At one point, standing by the lane with the spring shelf visible across the field and survey ribbons snapping in the wind, he admitted in a low voice that the original title review should have found the 1908 restriction. Ada said, "It should have." Then she looked back toward the eastern pasture, where grass had begun to return over filled earth, and added, "But systems miss what people stop insisting on." Construction in the western corridor finished that summer. The structures stood where August Kincaid had forced them to stand 85 years earlier, along the lane where they could be seen from the house but did not cut through the wet heart of the field. Hay still grew clean across the north pasture. In heavy rain the spring shelf still carried water the way it always had, quietly, correctly, invisibly, because the ground had not been broken where older hands knew it must not be. Eli rode past in July and stopped at the gate. The field looked almost unchanged, which is one of the strangest features of a narrowly avoided loss. The evidence of victory is often the continuation of ordinary life. No monument. No headline. Just beans or hay or pasture exactly where they still belong. But the story did spread, because stories like that always do. At the feed store. In church parking lots. At the tire shop in Dawson. In waiting rooms where men in seed caps and women with account ledgers on their laps pass hard-earned intelligence to each other in fragments. Not that Ada had beaten some giant in a dramatic showdown. The truth was more useful than that. The truth was that she had understood the hidden system better than the people trying to use it against her. She knew that land is governed by memory only when memory is backed by record. She knew that copies can narrow rights as easily as they can prove them. She knew that when institutions say there is no time, that is often the precise moment to go slower. Joel Ramsey, who had told her on the first night that once the drilling starts the thing is over, spent the next year correcting himself to anyone who would listen. He said the worst mistake a person can make with official paper is assuming that the version handed to them is the whole truth. Miriam Shaw started telling younger farmers to pull complete title history before signing anything that crossed a fence line. Even Luther Bell, who had learned caution in court the expensive way, began saying there are two kinds of hopeless fights, the ones you should never start, and the ones you only think are hopeless because the crucial page is still in a basement. Years later, when pipeline men came through the county with glossy maps and well-rehearsed urgency, more than one landowner went first to the recorder's office instead of the kitchen table. That is how real change spreads. Not through slogans. Through altered habits. Through one county learning that the system is not a single locked door but a maze built by documents, and that people lose not only when the law is against them, but when they never discover which part of the law is still quietly on their side. Ada herself never romanticized any of it. When people asked whether she had been certain the old restriction existed, she said no. Certainty is for salesmen and foremen. What she had was instruction. Her father had told her enough for her to know what to search for, and enough to know that searching was not foolish. She said the hardest part was not the hearing, not the lawyers, not the company trucks at the fence. The hardest part was the stretch between remembering that something once protected the field and proving that the protection had not died in memory alone. That is the distance most people never cross. They feel a truth in their bones, but the modern world does not honor bones. It honors what can be stamped, indexed, copied, cited, and carried into a room where strangers decide what is real. The hidden system beneath this entire story is simple and devastating. Bureaucracy rewards the party that can move first, but law often rewards the party that can go deeper. Institutions count on surface review because surface review is fast. Surface review is affordable. Surface review produces schedules. But deep record is where old limits wait. Deep record is where a dead grandfather can still argue with a modern corporation and win. Deep record is where local knowledge stops being dismissed as folklore and becomes evidence. And that is why forgotten paper matters so much. Not because paper is magical, but because it is one of the few ways a person can make a boundary outlast their own lifetime. Ada's grandfather had not protected that field with force. He protected it with foresight precise enough to survive men he would never meet. He understood that one day the threat would not look like trespass. It would arrive with licenses, logos, engineering maps, and the language of progress. So he built the defense in the only place progress still has to stop and read. After Ada died, the Kincaid deed packet passed with the land, and attached to it was a certified copy of the 1908 corridor restriction, indexed properly now, impossible to ignore without deliberate misconduct. Eli Mercer, grown by then in farming acreage of his own, kept a photocopy in his steel file cabinet beside tax maps and crop insurance forms. The first time a land agent came to him with a proposed access agreement, Eli did not argue, did not posture, did not say yes or no. He thanked the man, shut the gate, and drove straight to the county recorder to ask for everything. All the way back, he said. Every record. Because once you have seen how close a field can come to being taken by summary, you never again confuse a neat packet with a complete truth. And maybe that is the part that changes everything. Not the injunction. Not the settlement. Not even the towers moved to where they should have been in the first place. The part that changes everything is the realization that power often hides in old language nobody bothers to read, and that entire systems depend on ordinary people believing they are too late, too small, or too tired to go looking. Ada Kincaid went looking. She walked down into the dust and damp of a county basement, found the sentence the future had tried to outrun, and brought it back into daylight. And because she did, the field kept holding water the way it was meant to, hay kept growing where steel almost stood, and one valley remembered that sometimes the difference between losing and keeping what is yours is not strength at all, but the refusal to let history remain buried.